Imagine this. You get fantastic marks, you're ready for your dream college, but you're still denied a spot. Well, that's exactly what happened back in 1962, and it kicked off a legal fight that would literally define the limits of affirmative action in India. Today, we're diving into M.R. Balaji versus the state of Mysore, a case that set a rule we are still debating right now.
At the very heart of this whole story is a massive tension, and it's captured perfectly in this quote from Dr. B.R. Ambedkar. Think about it. The brand new nation was facing this monumental task. How do you build a society on the principle of pure equality while also giving a helping hand to those who've been systemically left behind for centuries?
And this right here, this is the core question. On one hand, the Constitution says you can't discriminate, period. But on the other hand, it mandates the state to help out its weaker sections. So how on earth do you do both of those things at the same time? The M.R. Balaji case took that exact question and put it to the ultimate test.
Okay, so here's how we're going to break this down. First, we'll look at the constitutional dilemma at the center of the whole issue. Then, we'll get into the controversial government order that basically lit the fuse. After that, we'll unpack the huge legal challenge it sparked. And of course, analyze the Supreme Court's landmark ruling. And finally, we'll look at the powerful legacy of the 50% rule that came out of this case, a rule that is still shaping India today.
So, let's set the stage. We're in post-independence India. The new nation is built on this beautiful idea of equality for all, but it's also dealing with the deep, deep scars of the caste system, which had left entire communities socially and educationally in the dust.
So, to tackle this, a really crucial clause, Article 15.4, was added to the Constitution in 1951. The best way to think about it is as an exception to the main rule against discrimination. This is the clause that gives the government the power to create what we now call affirmative action policies, or these special provisions.
So you can already see the conflict brewing, right? How far can these special provisions actually go before they start stepping on the fundamental right to equality for everybody else? This was the incredibly fine line that the government and the courts had to figure out how to walk. And this whole abstract constitutional debate, well, it was about to get very, very real. And the flashpoint for all of it was the state of Mysore, which we now know as Karnataka. The government there tried to solve this problem, and in doing so, they accidentally triggered a national firestorm.
On July 31st, 1962, the state of Mysore issued an order that reserved a truly staggering 68% of all seats in its best medical and engineering colleges. Just think about that. This left less than 1/3 of the total seats open for everyone else to compete for based on merit.
Let's look at the breakdown. Just 32% of seats were left for general merit. The rest, a whopping 68%, were reserved. Now 15% went to scheduled caste and 3% to scheduled tribes, which was fairly standard. But here's where they did something new. They split the rest into two new subcategories, reserving 28% for backward classes and another 22% for what they called more backward classes.
Now, this wasn't just some random number they pulled out of a hat. It was all based on a report from the Nagangata Committee. And here is the crucial part. That committee basically said that a person's caste was the main, if not the only, thing that determined if they were socially backward. Caste became the dominant factor for who got these reserved spots.
Well, as you can imagine, this 68% order was challenged almost immediately. A group of 23 students, including a guy named M.R. Balaji, had been denied admission even though they had higher marks than some of the students admitted under the quota. So they took their fight for what they saw as fairness straight to the Supreme Court.
So the battle lines were drawn. The students came out swinging, calling the order a fraud on the Constitution. They argued that using only caste was totally irrational, that splitting backward classes into two groups wasn't justified, and that, come on, 68% was just way too much. But the state of Mysore fired right back. They said their policy was rational, it was completely justified by the Constitution, and hey, there was no line in the Constitution that put a limit on how high reservations could go.
All right, so with all the arguments laid out, the stage was set. The Supreme Court was about to deliver a judgment that would go on to define the boundaries of affirmative action in India for decades, and I mean decades, to come.
And so, on September 28, 1962, a 5-judge Constitution bench of the Supreme Court, led by Justice Gajendra Gudkar, delivered its verdict. And because it was a full 5-judge bench, its ruling carried an enormous amount of weight.
The court's ruling really stood on 3 massive pillars. First, and this is the big one, it created a ceiling.
It said that reservations should generally be less than 50%. The logic was pretty simple. A special provision is an exception to the rule of equality, and an exception can't be allowed to swallow the rule itself. Second, it said you can't use caste as the only factor for backwardness. The court insisted it has to be both social and educational backwardness. And third, it struck down that whole idea of backward and more backward classes, saying the Constitution just didn't support that kind of subdivision.
And the court did not mince words. It declared the Mysore government's 68% reservation order unconstitutional, calling it a fraud on the constitutional power. That is incredibly strong language. It was a powerful message that, yes, affirmative action is necessary, but it absolutely has to be applied within reasonable and rational limits.
So, okay, a case from 1962. Why does it still matter so much? Well, the Balaji judgment wasn't just about settling one dispute in one state. It set a fundamental rule for the entire country. You can actually trace its journey right here. It all starts in 1951 with Article 15.4, which opens the door. Then, boom, 1962, the Balaji case sets the 50% cap. 30 years later, this rule gets cemented in the famous Indra Sanhi case. And even today, that 50% ceiling remains a cornerstone of reservation law, even as it's constantly being challenged and debated in the courts and in politics.
Ultimately, what the Balaji case did was force a fundamental shift in thinking. It pushed the entire conversation away from a simple, one-dimensional, caste-only approach to something much more nuanced. The verdict really championed a balanced path, one that tries to fix historical injustices without creating brand new ones.
And all of this leaves us with one big, lingering question. India has changed so much since 1962. So, with all that social change, is the 50% ceiling, the balance that the Supreme Court struck all those years ago, is it still the right framework for achieving justice and equality in the India of today? Well, that remains the very heart of the debate.